The U.S. Supreme Court this week ruled that sweeping immigration raids in the Los Angeles area can continue. The ruling lifted a federal judge's order banning government agents from making indiscriminate immigration-related stops. And joining us now is attorney Stephen Montoya, partner at Montoya, Lucera and Pastor. Good to see you again. Thank you so much for joining us here. So
good to see you.
So the Supreme Court lifts the federal judge order. What exactly was going on and is going on in Los Angeles?
No one knows, including the Supreme Court. And the Supreme Court exacerbated the situation by issuing an order vacating the temporary restraining order, which was scheduled to expire automatically later this month at a full evidentiary hearing. See, because the Supreme Court vacated the temporary restraining order without opinion. Justice Kavanaugh's opinion was not an opinion of the court. It was just his own personal judicial opinion, a concurring opinion that is not binding. So, Ted, there is no order. The court didn't explain its order, and the case is still pending in the district court and in the United States Court of Appeals for the Ninth Circuit, but they have no guidance from the court because the concurring opinion is not binding.
Yeah.
So who knows why they ruled the way they did?
Well,
it was a reckless thing to do.
Not only that, who knows what it means? Does it mean Los Angeles only? Does it mean other areas of the country?
No one knows. No one knows. And no one even knows what it means for the lower court case, because it could be that the court vacated the district court's order because it was a temporary restraining order, and the Supreme Court thought that there should be a full evidentiary hearing on the merits, which didn't take place. That could have been it, or it could have just said, hey, they can do whatever they want, but it didn't say one way or the other. So honestly, that's why I use the word reckless. Ordinarily, litigants and the people look to the Supreme Court for guidance. It gave no guidance in this case, only confusion.
Justice Sotomayor, in dissent, said this is a quote, "We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work at a low-wage job." Is that what's happening here?
We don't know. There's a strong case that could be made that that's what's happening here. But because the court didn't explain itself, once again, we don't know. I've read both lower courts' decisions. If you read what the district court found preliminarily, it's really a horrible story. United States citizens, a native-born citizen of the United States, grabbed, detained, they take away his cell phone, they take away his real ID and don't give it back and rough him up and then let him go. He was only stopped based upon the way he looked. He looked Hispanic and he was Hispanic, but that's not a reasonable suspicion under long existing case law. In preparing for this show, I was trying to trace how long the doctrine of requiring a particularized individual suspicion in order to justify a detention, and it goes back over 50 years.
So how is this not then a violation of, what is it, the Fourth Amendment? Reasonable search, is this reasonable search and seizure?
I don't think it is, but the majority of the court might agree. We don't know why they vacated, once again, the opinion, and that's why I go back to saying that it really was a reckless thing for the court to do, and it has caused confusion. It's caused chaos. People are saying, people are justifiably fearing that racial profiling has become legal, because that's what was going on in the streets of Los Angeles, and I'll explain. Instead of looking for, hey, we've heard that Juan Martinez is undocumented, let's go find him and see if we're right. They were just stopping Hispanic-looking people on the street, on particular streets where working people would gather sometimes waiting for a job and sometimes waiting for just the bus, and they would demand that they prove that they were in the United States lawfully.
And yet the administration says all they're doing is enforcing federal immigration laws.
Yeah, but that's not true, because federal immigration law has always required individualized suspicion. That's fundamental to due process. And remember, federal immigration law doesn't trump the Constitution. Federal immigration law operates within the confines of the Constitution, and the Constitution has always required individualized suspicion.
Legally, the administration says that the block, the temporary block that's out of there right now, was unlawfully hamstringing law enforcement efforts. Is there a point there?
Was it restraining them? Yes. Was it hamstringing them? I would say no, because under due process, okay, suppose we take this to the state of Arizona and we take it to Nogales, Arizona, the United States side. There'll be a lot of guys who look Hispanic there, speaking Spanish, dressed in work clothes, and most all of them were born in the United States. So does that mean that all of them can be lawfully stopped and questioned regarding their citizenship? I think not.
Last question here. As you mentioned, I believe this is obviously still pending here. Federal court, appeals court, I guess, federal appeals court. This means this could wind up back at the Supreme Court?
Yes, and it also means that the same thing could happen again. The district court could make the same ruling after a complete evidentiary hearing, and that could go to the Ninth Circuit. It would go back to the same panel. They could issue the same per curiam unanimous opinion, and it could go back up. And that's very likely to happen, because this district court judge heard a lot of evidence. I thought that she was mistaken, quite frankly, in deciding it without a full evidentiary hearing. I clerk for a federal district judge, and most district judges, before they enter any type of restraining order, like to have a fulsome evidentiary hearing. That's what due process counsels, and that should have been done in this case. It wasn't, but the evidence was overwhelming in favor of the temporary restraining order.
Stephen Montoya, Lucero, and Pastor, our go-to guy when it comes to constitutional and Supreme Court issues. Thank you so much.
Thanks.